on the prosecution of corruption matters, Chief Obona Obla, and also Professor Osanoye of Secretary to the Presidential Committee on Anti-Corruption, the representatives of the ICPC and the EFCC are also welcome. My learned brothers Silk that are here in their numerous arrays, special mention must be made to my good friend Rotimi Jacobs, SAN, who I'm sure will make an interesting contribution in due course to the discourse. We've been on the same side at times and on different sides on many occasions. Learned colleagues that are here, gentlemen and ladies of the media, distinguished ladies and gentlemen, I apologize if I missed out anyone that deserved mention. I think I will be saved by the saving clause of all protocols duly observed. I welcome you to the second quarter seminar, although it's coming a bit late, of the Rule of Law Development Foundation. The chosen topic is the remit of criminal courts and the role of legal practitioners in corruption cases under the existing law. This topic is apt and is coming on the heels of extensive analysis of government and other stakeholders reviewing the current fight against corruption in Nigeria. I note that on the 18th of July 2016, this is not the first time that allegations have been made against defense lawyers to the effect that they delay criminal cases or corruption cases. It was first alluded to by no greater personality than the President of the Federal Republic of Nigeria on the occasion of the opening of the annual Bar Conference of the Nigerian Bar Association in August 2015. Indeed, the President queried why lawyers should defend persons alleged to have been engaged in looting the country. In the course of the year, several other personalities, including members of the Presidential Committee referred to above, the FCC chairman, and senior lawyers affiliated to them, took turns in maligning defense lawyers as being unpatriotic just because they defended persons accused of committing crimes against the treasury and coffers of the state. The frequency and tenacity of these allegations have begun to assume propaganda dimension, such that if the truth as to the mode and way and manner of prosecution and defense of corruption cases is not clearly brought to the fore of national discourse, then defense lawyers will be a much maligned breed of professionals, in bracket, endangered species, in this country, and reputations that have taken years to construct will be evaporated in a brief moment. Undoubtedly, if left unaddressed, these allegations will no doubt have a deleterious effect on the image of legal practitioners in this country, especially when they have been accused and tried in absentia for effectively frustrating government's anti-corruption agenda. The phenomenon of accused persons defending themselves is cruelly referred to as corruption fighting back. I think Professor Sagi is the one that said that. Had government thought it fit to invite all stakeholders to the aforedescribed seminar or roundtable discussion, the truth would have emerged that defense counsel are ministers in the temple of justice and would do nothing outside the rules of professional ethics in the course of the discharge of these duties. This is imperative so that the truth may be told about our criminal justice system. Crime, the notion of crime and criminality in Nigeria. Crime can in elementary terms be defined as an act or conduct committed by a person that violates the stipulated expectations and norms as laid down by the state in a written law. Such act or conduct usually invites sanctions upon proof in a court of law of the offense in question. This is in line with the provisions of Section 36(12) of the 1999 Constitution, which provides as follows, in quote, "Subject as otherwise provided by this Constitution, a person shall not be convicted of a criminal offense unless that offense is defined and the penalty therefore is prescribed in a written law." And in this subsection, a written law refers to an act of the National Assembly or a law of a state, any subsidiary legislation or instrument under the provisions of a law. Consequently, it is expected that for any conduct to be labeled as a crime, an act of the National Assembly or a state law must spell out the nature of the conduct or misconduct and the punishment associated with it. Thus, conduct like rape, murder, stealing, criminal breach of trust, forgery can be classified or are crimes. Because Nigeria is not isolated from the world and because it is part of the human community, it possesses its fair share of social deviants and others who flout the law. The difference between Nigeria and some other countries is that while those other countries are able to contain the rampancy of crimes through their own justice system, Nigeria is unable to achieve that benchmark. If we get it right in Nigeria, our criminal justice system should be sufficiently empowered to contain the excesses of those who have a penchant to flout the law. Obviously, there is something innately wrong with a system where people seem to think that crime and criminality pays, and people either take delight in the commission of criminal offenses or glamorize those who have benefited from the proceeds of crime. The absence of infrastructure and other materials to guarantee a working criminal justice system is the bane of progress in curbing crimes and criminality. The notion of crime in Nigeria, though exceedingly detested or detestable, is that it pays. People think that crime pays. However, this perception has been compounded by government itself, whose constitutional duty is to provide for the people peace, order, and good government or good governance. The equality of the law read out by government usually determines the effectiveness of the criminal justice system. Consequently, if there is no legal infrastructure to fight crime, the society fighting crimes in the direction of monetary offenses alone, as opposed to fighting all crimes. The notion of what a crime is or what a criminal offense is, in the perception of this administration, must not only change, but must be seen to change. The resources of government must be allocated equally to fighting all forms of crimes, and judicial time must be allocated equally to the competing case interest. This calls for effective case management, which is still a strange or alien phenomenon in our judicial system. It is our submission that it is against the principles of the rule of law for a class of criminal cases to take priority over other classes of criminal cases. It is hoped that government will make suitable adjustments. The correct fight against anti-corruption vis-a-vis the rule of law. While this government, that is the Buhari administration, has shown great passion, albeit lopsided, in its fight against corruption, there is clear evidence that it is lopsided and other crime fighting, there is clear evidence that other crime fighting agencies have been neglected. Surely, the Nigerian police force, which body is recognized by Section 214 of the Nigerian Constitution as the only police force for Nigeria, and which provides that subject to the provisions of this section, no other police force shall be established for the Federation or any part, are among those that have been neglected. Again, it is true and correct that the principles of the rule of law postulates, one, that no one is above the law, and two, that government business, that is day-to-day running of government, must be conducted in accordance with the regular law, as opposed to resort to arbitrary powers by those in authority. As stated earlier, the past 1 year has seen government embark on a revamped anti-corruption war, in which those who are alleged to have enriched themselves with government funds have been charged with various crimes in several superior courts all around the Federation. This is a good thing. We submit that fighting corruption in itself is not a bad thing, and all right-thinking citizens must or ought to support the fight against such a cancerous scourge within our system. However, certain unethical unfortunately, that is not only contrary to our Constitution, but is a brazen violation of quite a number of international treaties that Nigeria subscribes to. See, in Nigeria, a defendant in a criminal matter possesses a constitutional right to counsel of his own choice, and the deprivation of this right is one of the worst forms of constitutional violations that can be inflicted on such a vulnerable person. It works this way. By systematically branding known defense lawyers as agents of corruption, fighting back, as people who use their knowledge of the law to delay trials, the message being put out to the public is to say that these group of lawyers are saboteurs who, for a fee, are willing to overturn government efforts at ridding the society of crimes of such nature. Surely, the intention is to direct public odium and contempt against this corps of well-trained professionals whose only offense is that they have specialized in an area of law that is now relevant. They have by no choice of theirs become counsel of choice for persons charged for financial crimes. The propagators of such hate message against defense lawyers know that specialized training is required to be able to prosecute or defend persons charged with proceeds of crime offenses. Their expertise is available to government as well as to individuals and organizations. No one should then be bitter if a lawyer offers his services to persons who in good time within the short space he is usually allotted. Indeed, and invariably, in the interest of a smooth prosecution of a matter, it is usually imperative that interlocutory applications are brought and considered. Examples of this kind of application is legion, and we'll deal with it in the second part of this paper. Section 36(6) of the 1999 Constitution provides sufficient safeguards for all stakeholders to work with, and it provides as follows. Every person who is charged with a criminal offense shall be entitled to A, informed promptly in the language that he understands and in detail the nature of the offense. B, be given adequate time and facilities for the preparation of his defense. C, defend himself in person or by legal practitioners of his own choice. D, to examine in person or by his legal practitioners the witnesses called by the prosecution before any court or tribunal, and obtain the attendance and carry out the examination of witnesses to testify on his behalf before the court or tribunal on the same conditions as those applying to the witnesses called by the prosecution. And E, have without payment the assistance of an interpreter if he cannot understand the language used at the trial of the offense. The observance of these rights will greatly improve the integrity of criminal proceedings in this country. Where they are not observed, they amount to unethical practices, all in the name of showing that there is progress in the fight against corruption. And this amounts to a great assault to the law of the land and constitutional process. It amounts to a disregard to the provisions of Section 36(6) of the 1999 Constitution, referred to above. The effect of these far-reaching constitutional rights is to ensure that there is a level playing field for all parties before the court. This is affirmed by the provision of Section 66B of the 1999 Constitution as amended, which provides thus. The judicial powers vested in accordance with the section of the Constitution A shall extend, notwithstanding anything to the contrary in this Constitution, to all inherent powers and sanctioned in the court of law, and B, shall extend to all matters between persons and between government and authorities and to any person in Nigeria, as well as to actions and proceedings relating thereto, for the determination of any question as to the civil rights and obligations of that person. The foregoing provisions confirm the obvious fact that every person that appears before the court is equal, and no one person is superior to the other. It is therefore wrong for the executive arm of government, who is simply a person, as approved by Section 6 of the Constitution, to go about throwing its weight around as if it owns the court, and that others are merely prisoners of war or captives before those courts. The executive does not own the court. It is just another suitor before the court. It should not go about flexing muscles merely because it's an arm of government and dictating how lawyers should conduct themselves, when it is not its function to do so. The mere fact that government, that is the executive arm, possesses all the instruments of coercion, the police, the army, the state security, Ministry of Finance, Ministry of Justice, and all agencies that matter, does not make it a superior body or agency to the judiciary. Consequently, the executive must draw a line between its acclaimed powers and those of other arms of government. To carry on as if it owns the courts is to detract from the neutrality or the independence of the judiciary. The greatest characteristic or powers of the court or tribunal is as stipulated in Section 36(1) of the 1999 Constitution, which provides, in quote, in the determination of the civil right and obligation, including any question determined by or against any government authority, a person shall be entitled to fair hearing within a reasonable time by a court or other tribunal established by law and constituted in a manner as to ensure its independence and impartiality. Thus, the persistent attack on judges, court, and defense lawyers is a calculated attempt to intimidate the judiciary and allied stakeholders and to derail its independence and impartiality. Judiciary should be allowed to operate in an atmosphere devoid of fear, intimidation, harassment, accusation, investigation, name-calling, and other intimidatory tactics. Granted that there are a few bad eggs in the system, that does not warrant the situation where the baby will be thrown away with the bath water. Issues militating against a functional criminal system in Nigeria. One of the issues militating against a functional criminal justice system lies in the expectation of the executive that there can be quick or accelerated results in the fight against corruption. That would indeed be a tall order. The fight against corruption is dependent on the existence of a viable criminal justice system. If over the years there had not been enough legislative or financial investment in the infrastructure that will deliver a cogent criminal justice system, then it will be a pipe dream to expect that overnight, without building the foundation for such a valuable criminal justice system, that qualitative justice can be delivered therefrom. It is necessary to unravel the causative factors of the deficient criminal justice system that we are currently running. And it is necessary to enter a caveat that that exercise cannot be achieved in this welcome address. While I was president of the Nigerian Bar Association, the bar organized 2 reform conferences of our criminal justice system, one in Abuja and one in Asaba, Delta State. And their reports are well documented. I'm sure they are lying on shelves somewhere. If the truth has to be told, the bane of criminal prosecution and success in court lies in the weak investigation procedures embarked on during the pre-trial stages of a case. We have stated times without number that the investigation process is ridiculed or riddled with a lot of negative factors, stemming from corruption to the act of or know-how and training of the personnel that carry out the investigation. Thus, cases that ought to be won, the cases that ought not to be won by a defendant end up being lost by the state merely because zero investigation has been conducted before the case was brought to court. The state of affairs is exacerbated by the penchant of prosecuting agencies to work towards the publicity of cases rather than working towards the result. It is common knowledge to see the confidential facts of a case together with the statements made by the accused persons on social media, laced with juicy comments and innuendos suggesting the guilt of the suspect or the accused. The damage done by trial, by media, is incalculable, and this is a deliberate strategy by the propaganda arm of government in its bid to show that government is working towards its desired objectives, to bring to the public domain matters which should have been reserved for the judiciary to assimilate and adjudicate upon. First, while corruption cases are in themselves very terrible crimes against the people of any nation, the secret of success by any government is not to discriminate against any form of crime. All crimes have its victims, and no one victim suffers more than the other in relation to the effect. Compare the pain inflicted by herdsmen or so-called herdsmen, which takes away lives, and those ones by financial looters, which just takes away money. I think they should be subjected to the same degree of concentration when you investigate and prosecute. So we all have an equal stake in the criminal justice system and have an equal desire for justice to be served. Money, therefore, should not be the be-all and the end-all. In our adversarial system, the golden thread, as eloquently put by Lord Sankey in Wilmington against DPP, is that an accused is presumed innocent until proven guilty, and that it is better for 9 guilty men to go scot-free than for one innocent person to be wrongly convicted. A defense lawyer is therefore trained right from the cradle to respect these rights and to fight for them. A defense counsel will resist A, a situation where the presumption of innocence is inverted; B, where bail is unjustly refused; C, where extraneous matters are introduced into the trial in order to deprive the defendant of his liberty during the pendency of a case; D, where the defendant is not given adequate time and facilities to prepare his defense, such as where immediately after bail is granted, the court announces that trial must start; E, where the court short-circuits the process of testing whether a statement is confessional or not; F, where the court passes derogatory remarks on the attitude of counsel merely because directions are sought at necessary stages of the proceedings, etc. All these factors have at least four examples each that if we were to break down, we will give, but they are not necessary at this point. Now, the criminal defense connotes every lawful measure to be taken by a defense counsel in the defense of his client, so long as such measures are not a breach of the rules of professional ethics. Consequently, the making of preliminary applications on behalf of his client under the ACJA does not amount to delaying tactics. It is obvious that state or government or even its agencies do not appear to have engaged in the factual analysis of international best practices, of what obtains in other countries, in order to find out the timelines between the introduction of a criminal charge and the commencement of hearing. If you check South Africa, the UK, and the USA, which the second part of the paper deals with, you find that no criminal matter can start and be concluded within the frame of 3 months, 6 months, or even 9 months. These are backed up by empirical evidence. This is not to say that some cases cannot be concluded within this period. Cases where the defendant or the accused pleads guilty can of course be concluded even within hours. But a case involving a complex financial issue cannot be expected that justice should be sacrificed at the altar of speed and velocity. Apart from the foregoing, we seldom see members of government, especially those who criticize the system in court, to watch proceedings before jumping to the conclusion that it is trial lawyers that are causing delays in the system. And by this I mean, I haven't seen Professor Bolaji in court, and I've done quite a number of cases, at least to look at whether it is true these people are causing delays by their procedures. We'll come to that. The chairman says nobody is on trial. It is suggested that high-ranking personnel in the FCC, in the police, the Presidential Committee on Anti-Corruption, should take time from time to time and come and watch proceedings in court so that they make up their minds whether what ought to be done. Apart from the antics, supposed antics of defense counsel, these bodies are manned by very talented and highly specialized individuals who know what the lacuna is in the law by watching practically the inefficacy of our present laws. Their proximity to government will assist in bringing the much desired reforms. We do not want to think that at one time we were on the same side protesting that there was not reforms. Now that they're in the corridors of power, we propose that they carry our message that it is not yet Uhuru and that more needs to be done for the courts to be adequately equipped with the materials that they need to fight all crimes and indeed corruption. It does appear, okay, let's take it from page 10. It is now common to hear superior courts of record stating that as a matter of policy, in quote, page 10. And page 10 deals with the attitude of courts which derogate on the rights of defense. That's refusing applications for bail and ruling on bail, refuse applications for bail pending appeal, refuse to exercise their inherent powers and sanctions that are provided in Section 6. Now, it is now common when you go to superior courts of record for one adjournment after the other, while the accused persons are in detention. Is it justice to keep the cases on the court list and not strike it out for want of diligent prosecution merely because the government would not like it? The answer is no. Also, was it right or constitutionally proper for the executive arm of government to have gifted the judiciary with sentencing guidelines at the same conference? In our view, comparative analysis of the administration of criminal justice system in Nigeria vis-a-vis criminal justice systems in the United Kingdom and the United States of America and South Africa. Now, what we have done is that all these systems have a model of the adversarial model of criminal justice. And the one in Nigeria is supposed or meant to meet international standards of such a system. That ACJ. I'm sure Mr. Rotimi Jacob will be able to enlighten us better on that part. Then the preliminary hearing, that is absent in our rules, pre-trial motion which the prosecution frowns against court-martial. The first indication of Nigeria's unpreparedness to meet its administration of criminal justice goal is that over 1 year after the introduction of the ACJA, there is no comprehensive criminal justice practice direction to complement the Act. A look at the criminal justice in the jurisdictions aforementioned shows proceedings. The provision complements the criminal procedure rules, which provides for the compliance with the rules. Under the rules, both the court and each of the parties appoint a progression officer who is saddled with the following duties: monitors compliance with directions, keep the court informed of events that may affect the progress of a case, etc. Now, we have given quite a number of examples and how bail and other issues are dealt with in other jurisdictions, contrary to how it is being dealt with here. And one thing is clear: the Nigerian courts, with respect to them, seem to be doing more of the reading than the interpretation of the criminal justice administration rules. And this situation is largely occasioned by inadequate direction on the application of the ACJA. In other jurisdictions, the fact that a defendant is on administrative bail is ab initio a ground for the grant of bail by court. If he has been attending invitation by the EFCC, why should this change when he starts to appear in court? Indeed, altering the bail terms truncates the smooth progress of the trial. You're going to look for someone with house in Lekki, in Maitama, or a traditional ruler, or a direct, and minimum time limits. However, the practice direction now further explains at page 20. It says, there is no rule of law or practice which prohibits two indictments being in existence at the same time for the same offense against the same person and on the same facts. But the court will not allow the prosecution to proceed on both indictments. They cannot be tried together, and the court will require the prosecution to elect the one on which the trial will proceed. Where different defendants have been separately sent for trial for offenses which can lawfully be charged in the same indictment, then it is permissible to join in one indictment, counts based on the separate trials, even if an indictment based on one of them already has been signed. Where necessary, the court should be invited to exercise its power of amendment under Section 5 of the Indictment Act. The reason I've brought this out is to show that in England and other jurisdictions, you can stay proceedings. But here, we have persuaded the legislature to impose a ban under Section 306 on the stay of proceedings, which indeed, in my view, is unfair to the rights of the accused person and the rights of the court to exercise its inherent powers of such courts under Section 6 of the Constitution. There are also applications for special measures direction. That means you want to consolidate, you want to do so many things, witness anonymity, and other directions, which shows that having flexible and comprehensive rules is better and more in advantage of the process of the criminal justice system. So I conclude at page 24. From the foregoing, it is evident that if the reform of administration of criminal justice in Nigeria were to be a student's PhD thesis, the ACJA is only but an abstract, which must be defined by subsidiary laws and legislations to give life and teeth to the act. So we are not there. Unfortunately, the ACJ has received more positive commentary than understanding. There is no known guide for prosecutors, not even a guide for the newly introduced plea bargaining regime. The implication of the state of events is that the ACJA may remain, in quote, beautifully dormant, while defense lawyers will be at the receiving end of the blame game for the inability of the Act to achieve its objectives. The truth of the matter is that the judiciary still needs to do more than reading the ACJA. It must return to its role of interpreting the law, and while doing so, supplement areas where vacuums exist in the Act. The law, the Office of the Director of Public Prosecution must also engage in the in-house training of staff to familiarize them with the new criminal law regime in Nigeria. It is also suggested, and we have always suggested this, that an independent federal prosecution authority be established within the Ministry of Justice. This agency should be modeled after the Crown Prosecution Service of the UK or the National Prosecution Authority in South Africa. And this body should be charged with the responsibility of not only prosecuting criminal cases, but with pre-trial investigation of every criminal prosecution. It will be a welcome development to see lawyers who will prosecute engaged in the investigation of a matter from the word go, so that they can be fully abreast, of the facts of the case when they are prosecuted. Also, the introduction of pre-trial hearing in the Nigerian criminal justice cannot be overemphasized. I was in a court where I think Mr. Jacobs wanted to make pre-trial remarks, and the judge found it strange and said, no, just go straight to calling a witness. I think at times it's best for skeletal arguments to be taken as to the scope and the nature of the case of the prosecution, so that the defense also explains what its defense is. Matters can then be narrowed down and all excessive issues eliminated. Consequently, reforms are of a continuous process. Hence, the ACJA unveiling party must be, that party that is still on, must end quickly so as to give room to new and additional processes of reform. It is expected that the practice direction that complements the ACJA is introduced timelessly to aid criminal prosecution, especially the anti-corruption crusade of the present administration. I hope I have been able to raise a few issues that will set the tone for the discourse and the interactive session. I hand over back to the chairman, the Honorable Justice Nguta.
Gentlemen, this is a thought-provoking paper. It took a lot of research. With the kind of people assembled here, if we are going to give this paper its due attention, we may stay here till the next day. Now, I want to make a few comments on the paper, and then it's your ball. Now, I'll start from the last point the senior counsel made about prosecuting counsel being involved in investigation. I give you my personal experience. While I was doing my national service in Benue State, I was involved in defending poor people and also prosecuting for the state. Now, a charge was brought. I think somebody was at a railway station in the night around 2 a.m., and then police arrested him. When the police came to give evidence, very tall, huge police inspector. Now, he started. He said, I went to a police station, and I saw this man sleeping. No, railway station, sorry. I saw this man sleeping. So I woke him up, invited him to the station. He refused. And so I had to drag him, and he punched me. I lost 2 teeth. That was the evidence. I told the court that we're wasting time here. He asked him, extended invitation to him, and refused. Why should he be charged to court? That was the end of the case. And so the commissioner of police was there. When it was over, he called me to his office. He said, next time there's a case, we're going to call you. You'll be part of the team. And he did. So I started taking part in criminal investigations, murder, rape, and all the rest of it. I think what they have, what Mr. Jacob has, is hearsay, second-class information. It should be there. And then take part in the investigation of the case so that he knows what to put across the court. Then I come to people's negative attitude towards lawyers. I give you one source. You look at television, you see a number of people are paraded by the police. What have they done? They are the criminals who have been harassing this place. They raped this one, they stole this one. The common makes up his mind that these are criminals, they should be in jail. In a few months' time, they're on the street. What happened? Is it not these lawyers? They took money and released him. Why arraign the people before you try them? I think it is wrong. He's presumed innocent until proven guilty. Now, if you arraign him before the national television, you're telling them this man is guilty. I think the police should stop that. And I come to the proof. I mean, the accused person should presumed innocent until proved guilty. I don't quite agree with that one. If you say he's presumed innocent until he's proved guilty, then it's just something waiting to happen. Eventually be proved guilty. That's what you're saying. Why don't we say he's presumed innocent unless proved guilty? I think it's better that way. Presumed innocent unless he proved guilty. If you say until, then you're waiting for the time he proved guilty. So let's be fair to the accused person. And Lord Sankey got it wrong. Yeah, I'm sorry to say that. And then, the hatred, not only prosecutors bear the negative emotion of the lawyer, every lawyer, and you have to bear it. That's your professional hazard. You knew that before you became a lawyer. So develop thick skin and make sure you do your work appropriately. And then the execution of court orders. When we talk about judicial independence, people think of money, people think of other things, but judiciary is not independent until it's able to enforce its own orders. You make an order that so-and-so be granted bail, should be released on bail. You go home. Has it been granted bail? It has not. What are you going to do? Who are you going to hold responsible? And then who is going to execute this order? It's the executive. You see, that's a violation of the separation of powers. You make an order, you want the executive. Maybe the order is against the executive, you want to execute it. We should have our own machinery. We should have our own marshals to execute our own orders. That's why judiciary be truly independent. Then the lawyers, just one last point. The statement accredited to the CJN, maybe it is practical direction. If he said that, I can tell you what the CJN meant. CJN didn't mean that no case will be struck out. What he meant is that if a criminal case is brought, and then prosecution is not going on, then the lawyer should should live up to his expectation. Either the prosecutor comes to court to say we can proceed with this case, we withdraw it. When he fails to do that, then it's incumbent on the defense lawyer to move the court to strike it out. In those cases, the matter will be struck out. The Chief Justice is not saying that this case can never be struck out. But if you no longer want to prosecute, tell the court so, and it'll be off. If you don't say so, counsel on the other side should move the court to strike it out. Again, that is why we don't want to give the impression that cases are struck off because people don't come. No, certain procedures should be followed. If you file a criminal case, corruption case for that matter, and then the first time the prosecutor was not there, no reason was given. Second day was not there, no reason was given, and the court strikes that. What happens? It's the court. Look at this man who stole money. They are struck it. Nobody will find out the reason why the court struck it out. Now, one other thing I want to say is about the press. The press must be involved in the fight against corruption to clean the society. By negative reporting, they are not helping us. On the 18th of this month, we were at the NJI. I know I was embarrassed when I saw the headlines the next day that the president, does that to the judiciary. But I was there, and I heard the president describe the effort of judiciary as tremendous, with the same president turn out to blame the judiciary for everything. No, I think these papers are syndicated reporters, and they made up their mind to put the judiciary in bad light. It is not fair. Again, one other issue I have against the press, one of the local papers in my state, somebody took the trouble to send it to me. And you know the headline, court sets armed robbers free, 3 armed robbers free. What do you think the other man will think about? Court sets 3 armed robbers free. You see, they did it deliberately to cast aspersion on the lawyers and the court. This time, the lawyers and the courts are together. You see? They could be alleged armed robbers, but not armed robbers. If they already are armed robbers, they'll be somewhere. See? So having made this point, I think I throw the floor open to you, and be mindful at the time that we didn't start in time. Later we charge him without corruption of time.
Just before we proceed, I'd like to recognize 3 persons who joined us while the first paper was being delivered. The first person is Ahmed Raji, SAN. Next to him is Tawo, Senior Advocate of Nigeria. Senator Joshua Lidani. And the former Speaker of Benin House of Assembly, Dr. Dan Yohemba. Just before, the special advisor to the president on prosecution had indicated that he would want to take the first shot. I'd like to invite him to take a shot. You can stay there. If you want the podium, that would be very good, so that the press the TV will catch it properly.
I want to pay my respects to the Honorable Justice Sylvester Guta of the Supreme Court of Nigeria, the coordinator of the Rule of Law Development Foundation, and all the senior members of the bar present here, all the members of the MBA present here. I greet you. I won't say more than that. If a justice of the Supreme Court has exonerated the president, then I don't want to say more anything concerning all the allegations that he castigated the judiciary. The president cannot do that. This president, you must have seen clearly, is a procedural person. He has tremendous respect for the rule of law. That is why when he was struggling to become president, he went to the Supreme Court 3 times. It's unprecedented because he believed in the rule of law. So he has tremendous respect, and he has shown that he doesn't interfere in the working of the other branches of government like the judiciary and the legislature. Even when he was tempted, to interfere in what is happening in the National Assembly concerning the struggle to elect a leadership for a National Assembly on behalf of his party. He refused to do that. So the president cannot intimidate and he cannot castigate the judiciary. I do not think that this seminar, I've seen the organizer. The organizer is involved in one of the matters that is in court. I don't know if that is the reason why this seminar was organized, because the case has become a very controversial case. And we have also tested the provisions of the administration of criminal justice in that case. And I have been present from day one to the last day when the matter was adjourned to September. All what we have seen is that there's a deliberate effort by some lawyers to ensure that matters are frustrated, matters do not go on. And this only happens when big men, the African big man, who has been notorious for the backwardness of Africa, is facing trial. And we cannot in this country have two standards of justice. Justice for the poor man, the dispossessed, the underprivileged, and then justice for the super elites. When the super elites is asked to account for his deals when he's in office, he will say, oh, because I'm a Hausa man, and I'm a thief man, I'm a Yoruba man, and I'm a Ibibio man, or an Efik man, I am a Muslim, I'm an Hindu, a Shinto, and so forth and so on. Whip up sentiments. The government is biased. The war against corruption is one-sided. But we know that every day, the poor people are sentenced to court, and they do not try, their lawyers do not make any attempt to frustrate matters. If the provisions of the section 606 as clearly, expressly, categorically says you should not ask for a stay of proceedings, and is there, why must a lawyer who is a minister in the temple of justice come to that same court, ask for stay? Then if the court refuses, he will go to the court of appeal, ask for a stay. Or if he has appealed over an interlocutory ruling, he will not go to the court of appeal, file a motion for stay, and then come back to the trial court. Oh, my lord, there is a motion for stay of proceedings in the court of appeal. Don't go on. Yes. So that is what we see. That is what we see every day. So, and which I think should not be the case, because lawyers are ministers. Lawyers are to protect the accused person, the suspect, the defendant, and the society, even though you are expected to work for the interests of your clients. So we should show much more than what we are seeing. And I do not think that the federal government is fighting only corruption, as shown in the paper delivered by the coordinator. The federal government is not fighting only corruption. The federal government is fighting all crimes. Piracy, kidnapping, terrorism, money laundering. It's not only crime or financial crimes we are fighting. And that is why the present government, through the office of the AGF, no, yeah, I'll round up, sir. The paper was so long, my lord. Yes, the federal government has set up the National Prosecution Coordinating Committee to complement the efforts of the DPPF. And in that National Prosecution Committee, we have investigators to assist the lawyers who are prosecuting. So I reject the accusation that the federal government has neglected the judiciary. In the face of competing resources, the federal government is doing its best to ensure that the judiciary is taken care of. And at the federal level, you see a lot of beautiful courts. And we see a lot of equipment there to help the judges. So the federal government is doing its utmost. Defense counsel should also help the system. Thank you very much.
This paper raised a lot of issues. If we have to discuss all of them, we'll be here till tomorrow. So, and again, let's confine ourselves to the issues here. Let's not mention a particular case. If you mention a particular case, well, maybe you're prosecuting the defense here, you start trying that case here. This is not a court. Let's find ways. There's no perfect system. We're not striving for perfection. We're striving for excellence. So your speech should be geared towards making the system excellent. Please.
Thank you very much, my Lord. I want to appeal and apply in advance, my Lord, that since this paper touched on so many things, my Lord should please indulge me to respond to all the key issues that I think it's only fair, and we're on live. It's only fair that this conversation is not one-sided. Let me thank Mr. J.B. Daudu. I'll try and be brief and concise. Yeah, for inviting the Presidential Advisory Committee Against Corruption. And I have to correct a lot of impressions that he has created. The first, that we had an event last week with the judiciary specifically, but that lawyers were not invited is not true. Indeed, the president of the bar was specifically invited. He told me he'll be out of the country. Sir, we wrote him a letter. If I had known that this was coming up, I would have brought it here. And not only that, requested that 10 senior lawyers be invited. So, I think that to make those generalizations, I take it that Mr. J.B. Daudu didn't have those facts. Second point is that on the 12th of July in Abuja here, we had an event specifically with the bar, to exchange views and look at some of these issues that Mr. Daudu has raised in his paper. Now, with the exception of Chief Awomolo and Michael Zekome, SCN, who was a panelist, many sons did not come, and I'm sure they were informed. So now, if the NBA, and the NBA was the one that sent invites, not the Presidential Advisory Committee, I'm trying to debunk the notion of us against them. Now, Mr. Daudu does not make any pretension that this meeting is an us against them meeting in the presentation. But I don't see an us against them. I see a common purpose in which we need to find a common ground. His presentation shows it, that is an us against them, and the agenda shows it, that is an us against them. But I hope I'll be able to debunk some of those. Second point, some of the defense counsels who claim that they are being vilified today were once prosecuting counsels for government at some time in the past. Some currently. They never raised some of these issues that they're complaining about now. They never did. Now that makes suspect the intent and the purpose of this conversation. I think that if we remove the divide, we can find a common ground, which is where I'm going to go to now. And I need to use that to be able to clear a lot of things. We should take note that there is a lot of complaints about ACJ, which my learned senior has said is, how did you put it? Is it military or something? Use an expression. It's a court-martial legislation. Sir, when professionals in any society, when professionals use their skills and set themselves against the society, they are going to get more and more regulations. Now, because the society will become edgy. Now, if we're told that defense lawyers are being accused, I think it's the legal profession that is on trial. It's not defense lawyers. The entire legal profession, whether you go to a meeting, you go to your church, wherever you go, once you're a lawyer, you know, and we're all part of it. So this conversation must be about that. Now, let me be specific to go to some issues. I've already talked about, there's this accusation that, I think I've referred to that because I have comments on virtually every paragraph. So yeah, I have comments on every paragraph. Let me just keep and go to. Now, there's this notion. The conversation that Mr. J.B. Daudu has raised this morning is a conversation in defense of the suspect, not society. Not society. Now, in any criminal case, there is the victim, there is the state, there is the society. Corruption, especially grand corruption, and the man who spoke before me, the representative of the Attorney General, said that when ordinary people commit offenses under the same legislation, we don't have all these shenanigans. We don't have these delays. we don't have these complaints, the law works against them. The law works against them. So what we have is a system that certain set of people, in my perception and opinion, and in the opinion of many people, have chosen to decide that that system will not work against them. So the point I'm making is that we should remember that corruption has victims. Grand corruption has many victims. When a man who has occupied public office is accused of stealing the money meant, for example, to provide schools, let us take note, because I don't want us to lose track of what this conversation is all about. This conversation is not that people are being convicted even though they are innocent. This conversation, the entire truth is that there is no determination of the cases. That's the point. These cases, there is no conclusion. So defense counsels cannot claim to have defended and got their clients off on the merit of any case. That's point number one. Point number two, my Lord Chairman made a point and said that if there is no willingness to prosecute a case, what stops a defense counsel from applying for the case to be struck on? There is no moral strength to do that in many of the cases we're talking about, because the cases are hanging by the antiques of the defense counsel. Let's do an evaluation. I didn't know the conversation was going to be like this. I have done a publication before I ever, as a civil society activist and an academic, just looking at cases from what I read in the newspapers, and it's in my car. And if people want it, I don't want to pretend as if this is about, it's just there in my car. I'll be willing to give everybody a copy. All I was looking at, what are these cases? What are the issues? Why are they not proceeding? If people are innocent, the court should be allowed to pronounce them innocent. If they are guilty, the court should be allowed to pronounce them guilty. Mr. Daudu has not said that innocent people have been pronounced guilty. We're saying this conversation is all about, please, let the innocent be pronounced innocent, let the guilty be pronounced guilty. The cases that are causing the problem, giving both prosecution and defense and the justice system a bad name, they are not reaching conclusion. So let's talk about how those cases will reach conclusion. That's very important. Then the other points that I need to focus on. There is this notion about if the offenses of looting is not the only criminal offense in the statute book. True. But we're in a situation in which corruption, grand corruption, is what has become push factor for other offenses. Where are the kidnappers? When a man refuses, steals all the money meant for schools and hospitals in his community, he has already created kidnappers. That's just the point. So if you don't focus on grand corruption, if you don't deal with those issues, all those other push factors, it leads to systemic dysfunction. So we've got to focus on it. And let me tell you, nobody is immune. Nobody is insulated. Not those of us in this room, not those who are walking or sleeping in the bridge. It is only a delayed effect before the effect of corruption, if it is not tackled, gets to the rest of us. So we need to bear that in mind. The other point that has been made is that I've said that economic and financial crime are push factors for all other kinds of cases, and if we deal with it, and look, how best do we, my Lord has advised we should not talk about cases in court, but we have seen the effect of corruption in increasing insurgency in the country and terrorism. So let's be honest with ourselves. You don't deal with it, those kinds of cases will escalate. Let's take a few more specifics. It is our submission that the principle of the rule of law for a class to take priority. I don't think it is an aberration for government to set priorities. Every government sets priorities. You could choose at any point in time. It's like a law enforcement agency, my Lord. A law enforcement agency in a typical day will receive complaints of criminality on different issues. They will then make up their minds what they are going to prioritize. All of them deserve attention. And this is not a Nigerian problem. It's a global problem. It's a global problem so that in determining what your priorities are, the government will decide its own priorities. Now, there's the talk about certain unethical practices associated with prosecuting agencies. True. I'm not absolving them. But more unethical practices associated with defense counsel. Plenty. So this goes both ways. And I think that our conversation should be about removing the unethical practices on both sides, not just on one side. There's a talk about the disregard for presumption of innocence. And I think that sometimes when the paper talks about best practice in rule of law, there are jurisdictions who shift the burden. And we have rules we have sections in our legislations today. If you are accused as having been a public officer all your life, you've never worked out of government, and then you are parading wealth beyond your income, and the law enforcement agency says, can you please explain to us how you made the money to buy this house, which far as strips all of your income from the day you started working, even if you are not spending any, hasn't the burden shifted? The burden has shifted. It's there. So why is there this complaint that when somebody who is a politically exposed person is being asked to justify something, you say, oh, you are impeaching the constitutional right? That's number one. Let's talk about this talk of stay of proceedings and whether there is a right of appeal or not. There's a constitutional right of appeal. It is not removed. It stays there. What is being said is that you have a right to appeal, but you can't do it now. Let's discuss this matter of your innocence or guilt, then you can appeal. So it is misleading to say that the right of appeal is either removed, truncated, or is not recognized. It is there. And the question is, do the courts have a right? Do we, as a country, do we have a right to say, we can say, please hold your right to appeal in abeyance. In abeyance. You can appeal. It's your right to decide to appeal, but you can't appeal now. Let's take all of these substantive issues, and then you can go on appeal. Now, very quickly, there is the allegation well, I've already talked about defense lawyers being branded and all that. The truth of the matter is that there are sufficient facts to justify this branding, but it's not just defense lawyers. I think it's all of us who are being accused. Now, there's been some allegation that the persistent attack on judges, courts, and defense is calculated to intimidate judiciary and allied stakeholders. Unfortunately, there's this presumption that when cases get into the media, it has been put there by the prosecution. It's not true. It's not true. There are situations and evidence which we have. It is the defense itself that puts information in order to gain public sympathy or to try and change the narrative. It is there. Now, my Lord will recall that, and you chaired one of the sessions last week on Monday, the very first session. We as a committee, we designed that program. We put there media threats to judicial independence. We put there. It wasn't by and we made it public. It wasn't by the request of the judiciary or by the defense. We know that there is a threat, if not reined in, to use the media, even though they have a role to play and it's important, to use the media to cause injustice. So it is again an allegation to say that, oh, well, it's the government or it's the prosecution and all that. If we are regarded as part of the executive, we put that there, that conversation, to look at the best way to make sure this doesn't happen. So I think it's important that we recognize that this is a common threat to everybody, not one side. But it's important not to take the narrative away that it is only the prosecutions who throw things to the media. In any event, my Lord, many times when cases just conclude before your lordships and the cameras are right there in front of you, is it only the prosecuting counsels who talk? It's not. The defense lawyers have their field day, whether at that point or by private interviews. Some defense lawyers are sought out for interviews and they go to town. So I think the guilt is on both sides if we're talking about this, and that we really need to say we must watch and caution ourselves, and what are the limits? We need to stay within it. I will soon round up, my Lord. Yes. Yes, I think, sir, it's only fair. Mr. Daudu's paper is very comprehensive, like you said. We need to respond to him comprehensively so that those who are watching and listening to us out there can get both sides of the argument. It's critical. Now, there is this conversation about the infrastructure that is required to make the criminal justice system viable. Regrettably, besides talking about the rules that are required, and I'm going to talk about that in a moment, Mr. Daudu has not told us about what sort of infrastructure that is. That's number one. He has suggested, oh, well, it should have indicated, if we're talking about stomach infrastructure, sir, I think that there is no doubt that Defense Counsel have better stomach infrastructure far more than prosecution. And all you need to do is to look at a typical case, my lord. A typical high-profile case, the defense has 10 SANs, the prosecution has, if they are lucky, maybe Rotimi Jacobs, and then one state counsel who probably came by public transport. So who is having stomach infrastructure? Is it the government or the defense? I think it's the defense who has stomach infrastructure, and they need to admit that. Now, the point I'm making is that the infrastructure that we need to improve the system, he didn't mention it. And I'm interested in that infrastructure. However, we should also not lose sight of the fact that the defense also exploits the absence of this so-called infrastructure. So when you are saying that the prosecution are asking for something when there is no infrastructure, is the defense not exploiting the absence of infrastructure to make sure that we do not get conclusion of cases? Conclusion of cases. So my argument is that let's drop the ball. The ball here is that cases are not concluding. Cases need to conclude. If I'm accused of having stolen a phone, my interest will be to have my innocence vindicated. Not for the case to be hanging for 20 years. I'm neither guilty, I'm neither innocent. A few quick more points, my lord. I'm sorry, just to round up. Yes, sir. Mr. Daudu talked about when he was president of the NBA and the initiatives that took place. I was a speaker in one of those initiatives on criminal justice reform. The question is, how far did the initiatives go? Now, part of this problem is because the bar itself is not playing the role it ought to play. The bar is compromised, divided. Why don't we confront those issues? Now, the point is that I'm trying to say, in other countries, the bar leads reforms, not from the back, from the front. A lot of the reforms you have seen in criminal justice administration, my lord, and I stand to be corrected, they have been led by civil society, not the bar. They have been led by civil society. Who are the ones who push for Administration of Criminal Justice Act? Who are the ones who push for changes in anything? It's civil society. So I think that we need to say that there are areas in which the bar could have done more, and they have unfortunately not done as much as they ought to do. There's been a suggestion that why should the executive deliver to the judiciary sentencing guidelines? Now that comment is ill-advised because it is driven by lack of information. First, the sentencing guidelines were prepared with judges being part of the process. That's number one. Number two, if there's an argument that no arm of government can, for example, have any input or impact in what another arm of government is doing, then why do we have executives submitting legislation to the legislature, draft bills? Why do we have them submitting bills? Why do we have private members' bills? Why don't we just say it should only be the legislature who will initiate bills and all that? I think that comment that you cannot have the executive making guidelines, they are called, which the judiciary have the discretion to accept or reject, totally based on existing laws. I doubt that Mr. Daudu has seen them anyway, and I offer publicly to give him a cite of those guidelines. Yes, I'm concluding, my lord. You know, Apostle Paul, in one of his gospels, he said, "Finally, my brother." I won't be Oliver Twist, my lord, but he wrote 4 chapters after "Finally, my brethren." I will not go as far, but I'll try to cut it down. I've talked about the constitutional right of appeal. I've talked about the sentencing guidelines. There's this conversation, there's a sentence that says that it is safe to conclude that the executive arm of government in Nigeria is guilty of interference with the judicial arm of government, either through comments, intimidatory tactics, such as investigation of judges and lawyers, and other conduct inimical to impartiality of the judiciary. Now, I think that this is a generalization that is very unfortunate. First of all, I think that the criminal justice system does not exempt anyone, subject to whatever we have provided. And if whatever we have provided says that anyone who infringes the law can be dealt with, why should using those very principles be an issue? Even though there is nothing that has been put out there in terms of specific examples, but I'm saying that as a principle, we should be careful not to make these generalizations. Finally, my Lord, my learned senior talked about training for prosecutors, guidelines for prosecutors, and all that. A number of the things, again, I take it as evidence that there is insufficient information and communication. There is a plea bargain guideline, definitely. The rules, of course, situate the final decision on plea bargaining before the courts, but there's a guideline that recognizes that, which the Attorney General's office is already privy to, okay, and has adopted, my Lord. Secondly, there's been training going on for prosecutors. I think the gentleman who spoke before me alluded to that. The Attorney General's office has not only set up a National Prosecution Coordinating Committee, he has also set up prosecution teams. He has talked about it, and the effect of all those are to improve some of these problems that Mr. Daudu has rightly identified. My final comment is that I think that it will serve the purpose of the justice system if we don't create an us against them scenario. Because I think that what affects A affects B. I do not think that defense counsel are in higher jeopardy than the rest of Nigerians. They are not. And defense counsel are not a special breed. In any event, maybe if there's an association of defense counsel formed, then we can know who are defense counsels. Rotimi Jacobs can become a defense counsel tomorrow, and my learned senior become a prosecutor tomorrow. And will this conversation change? So I think we should deal with the systemic issues. We need to work together, and my conclusion is that the point that we need to focus on is that those high-profile cases need to reach conclusion. Government has not said they must be convicted. We're saying the cases should not be hanging. Thank you very much, my Lord.
Now, I think I like the idea about unity. We are lawyers. We should stand together. If we create a divide and keep widening it, it's what for the society. You see, a lawyer is a lawyer, whether you're defending or prosecuting. The common man doesn't know the difference. The man who wrote, let's kill all the lawyers, did he say, let's kill all the defense lawyers or the prosecutors? So even here, let's find the means of working as a team. Again, this state of proceedings thing, it has a problem. Somebody raises this issue on jurisdiction. You say you cannot stay until that issue is determined. Suppose at the end of the day, the court decided there is no jurisdiction. What happens? There's another point we have not raised here. The victim, I think some of you mentioned the victim. How do we compensate this man who had gone through the rigors of trial, only to be told at the end, oh, go home, no case against you? So these are issues we should highlight. I'll go to this side now. Yes. Please, time factor.
I'm sorry to the Learned Senior Counsel. My Lord, I felt that if your Lordship look at the theme of this seminar, is the remit of criminal court and the role of legal practitioner in relation to corruption cases. That is the theme. But what I discovered in this seminar, I may title it as reply of defense counsel. Not because we have not said anything. Yes, I have my own. No, I have. So, my Lord, I want my Lord to because if your Lordship look at the paper read by the organizer of this, if he had given me this paper, my approach to this seminar would have been different. So, and I would have approached it in a different way, because there is nowhere I said that we can go back home and then get any improvement in the system, in the administration of criminal justice system. I think the purpose of this seminar is to address the problems and then to confront the problem, and then make recommendation on the way forward. I think that is the way we are officers of the court. Lawyers are officers of the court. We have a duty. We are the shining light of the society. We own a duty for a better administration of criminal justice system in this country. And I think that is the purpose of this seminar, but not in defense of the defense lawyer. So, and I think we need to change that attitude. That is why I prepare my own paper. And in my paper, my Lord, which I will give to my Lord and other person who wants my paper, which I will speak to the paper. I'm not going to read everything, my Lord. My Lord, I'm going to speak to this paper. I'm sorry to my brother. Please, where is the other copy? My brother Raji SM, please. So, because it's not a conflict between the defense counsel and the prosecution. We need to, are we pleased with the situation? We know the effect of corruption in our nation. We know how the corruption has undermined the development, the security of this nation, the development of this nation, the value of democracy, the ethic and values of this nation, the justice, and jeopardize the sustainable development. All of us, we know the effect. We note the effect of corruption. My Lord, and I look at it that, well, if the defendant is saying, or the defense counsel are saying, we don't have any blame. Blame the system. Blame the court. Blame everybody. Blame the prosecution. The investigation are shoddy. My Lord, I want to refer your Lordship to page 8 of my papers, where I stated a classical example of what the Supreme Court said in one of those cases, in one of these papers. And your Lordship will see the approach of lawyers, the defense counsel, and what the Supreme Court said concerning them, particularly corruption cases. Joshua Dariye and FRN is the case in part. Your Lordship, this is what your Lordship said. My Lord, here, presiding, this is what your Lordship said. It is not the duty of the learned counsel to resort to motion. Who is the person blamed there? Learned counsel. To resort to motions, aimed principally at delaying or even scuttling the process of determining whether or not there is substance in the charge as laid. In my view, this motion is a disservice to the criminal justice system, to the criminal process, and a contemptuous lip service to the fight against corruption. The tactics employed here is one of the means by which the rich and powerful cripple the criminal process. There are cases where accused develop some rare illness, which act up just before the date set for hearing in trial. They jet out of the country to attend to their health, and the case is adjourned. If the medical facilities are not available locally to meet their medical needs, it is only because due to corruption in high places, the country cannot build proper medical facilities equipped with state-of-the-art gadgets. There should be no clog in the process of determining whether or not the person accused of a crime is guilty, irrespective of his status in the society. Let me trace the genesis, and your Lordship trace the genesis of this case. And your Lordship concluded and say, appellant appeal to the Court of Appeal, and then appeal to this court. Your learned brothers also said something on that. Rufaivo's JSC. I quoted it there. It has been the practice in the Third Republic, commenced in 1999, for well-to-do individuals who face criminal cases to ensure that such trial never proceed. That is done by filing in court several irrelevant applications. Appeals are designed to stop the trial from proceedings to conclusion. This is a disturbing trend that has allowed to fester for too long. The court should rise and stop this disturbing trend in our criminal justice system. Happily, both court below and this court have done this. And I will also finally read on just what Justice Nweze said. I have noticed a worrisome trend in recent times. Affluent Nigeria, particularly the politically exposed citizens of this great country, imagine that they are above the law of the land, have perfected some awkward and graceless tactics of delaying their trial when they run into conflict with our penal statutes. The appellant in this appeal fall into that category. In 2007, about 8 years ago, leave was granted for him to appeal, to be charged. And this Lordship, all of your Lordship, unanimously resolved that and said, This is a major delay tactics. We had problem. Governors' cases were not going on. In that period, we filed about 15 cases against former governor in 2007. None of them were allowed to go on until the Administration of Criminal Justice Act. Until the Administration of Criminal Justice Act. So, my Lord, this is what happened. In that case, based on the pronouncement of the Supreme Court, can it be said that the defense counsel are exonerated from blame in the delay to justice of these high-profile people? It can never be, and it is not so. So, my Lord, if the Administration of Criminal Justice Law now rise into the occasion and now say, what are the prescriptions under that act? I put it there in the paper, my Lord. What do they do? Section 396, 221 says, we are not going to allow preliminary objection on prima facie case. You can't be filing prima facie case. Do your case. Wait until the trial. Then appeal. So that is the first step taken. But the defense counsel are not happy with it. They will still file and challenge, say there is no prima facie case. It might have gotten instances where the accused person, the high-profile personality, make confessional statement that admitting the offense, yet there is no prima facie case. And with respect to the Landed Senior Counsel, I refer to his case that gave genesis to this, the Abuja's case. I refer to it in page 8. It was one did it up to Supreme Court. That has opened the floodgate. That has opened the floodgate. Yes. So that has opened the floodgate. That has opened the floodgate for them, for the defense counsel to file even where there is no need. They don't believe in it. My Lord, and I also look at our rules of professional practice. And I look at the rule 30, where it stated that it is a professional misconduct for a legal practitioner to delay trial. And the coordinator is the chairman of the disciplinary committee. So, my Lord, these are the problems we have. So, there are other reforms that were suggested that I produced in the paper. The section 397, I refer to all those things. And on stay, I know that lawyers will not allow this. I pray that they will allow this process to work, the Administration of Criminal Justice Act to work. I pray that they will allow it to work because we need it at this time. This time, the state in which the nation is, we need the law that will ensure that justice is done as quickly as possible. And that is what we need. So I also refer to authorities that even say that section 306 are constitutional. They are constitutional. There's nothing unconstitutional about it. He referred to that the court has inherent power and sanction to grant stay. When you are talking about inherent power under section 6 and 6 of the Constitution, it's talking about where there is no statutory power, where statutes have not made provision for something. The Supreme Court in Akilu's case have made that clear, that where there are statutes regulated a thing, a power, then you don't exercise statutory power over it, inherent power. So it's no longer discretionary power. So they should allow the system to work. Nigerians we want this nation to change. We want Nigeria to change. My paper is very comprehensive, but I know that your lordship will not, the time will not permit me to go through. But I think I also need to react to some things. My lord, what I want to react to is where I talk about the case management that is recommended, that the court should manage the case. The case management aspect of this, where it's referring to that it is unconstitutional for them not to be given all the access, front loading of cases, no time for them to prepare. My lord, I refer to the court that, and he now went to England, went to other country and said, no, in other jurisdiction, there is provisions for time to prepare, to do a lot of things. My lord, in the case management thing I prepare at page 24 of my, I define what is case management and what the ACJA said in section 1 of it, that the system of criminal administration that it should promote efficient management of cases. Efficient management of cases. That allow case management. And the first step in that case management is that act now allow front loading of cases. That all witnesses that want to give evidence must have their deposition, must have their the prosecution must forward this material that it intends to rely on to the defense counsel. I stated that, but there's one thing I want to add to my lord. One thing is this: the defense counsel will never allow, in other jurisdiction, it's not only prosecution that they are front load. The procedure of case management that he referred to in England, there's provision that allow the defense, they have made it mandatory for the defense to give their own, to front load their own case. So I put it here, Section 6 of the Criminal Procedure and Investigation Act 2006 in UK. The requirement are stated here that the defense written statement must be there, and it must be served on the prosecution. And all those processes I stated in my paper. But the first attempt made in Nigeria by my lord, the Chief Judge of Federal High Court, in practice direction he made in 2013. Because the Learned Senior Counsel is talking about lack of practice direction. This lawyer will not allow the practice direction to work. Justice Awuta made this practice direction in 2013. In paragraph 5 of it, he's made it mandatory for the defense to bring out their case. Specify your defense. What do you have on the table? Serve it on the other side. This senior lawyer appeal, they challenged it in court and got it struck out. So the problem we have is our attitude must change. If the nation must change, Nigerians must change their attitude. There is no amount of reform that will work if we don't change our attitude. The nation will change once we are ready to change. That is my own.
Thank you. Now, I just want to say something about Darius' case. It's true we descended on defense counsel. Because there was no need for us to talk about, we treat lawyers as a group. We didn't single out this counsel here, defense counsel. There are other cases in which you berated you people. you know about the judge's case. Now, both lawyers, whether defense or prosecution, are guilty. That case was tried. When they got to the Court of Appeal, they lost, and they decided to come to the Supreme Court. Do you know what happened? 6 briefs, 6 different lawyers. They've been tried together and appealed to the Court of Appeal together. They had to split into 6. Now, in that case, one of the counts was that they breached an order, a directive of a minister. I had occasion to say that we don't have 2 criminal cases, one political and the other one non-political. Criminal cases are the same. Then again, you have prosecutors. Prosecutors now, they come with, I hope it's not happening now, they come with about 200 counts. How do you prove that one? Are you going to call Rotimi Williams? You cannot do it. Corruption in charges. Because by filing 200 counts, you already laying basis for failure. So, having said that, there is a dangerous person here. Do you know why he's dangerous? He's from the EFCC, he can arrest all of us here. So allow him to talk and leave, so that we can talk freely. He needs to do something else.
Thank you, my lord. I'm so sorry to jump in when my very, very senior counsels are here. But just to bring my chairman's goodwill message, he has asked me to convey his greetings to these organizers of the seminar and to apologize for his unavoidably absent because of other urgent matters. And I would like to say this as I hand back the microphone. I've been with EFCC right from inception. I'm one of their prosecutors. And I've been involved in almost all the cases right from inception up to now. And my experience has been this. Let me say this, and please, give me just 1 minute. What is happening in Nigeria, what terrorism is to the United States, is what corruption is to our country. My learned seniors who are here, if we don't fight this together, we're already seeing the results. We're already seeing so many. Last night, one of my young lawyers who work with me, the sister will be inducted on the 28th as a medical doctor. She died last night because of a bad road. She went to collect her gown for induction on 28th of this month, and their motor entered a gutter on the road, and so I started several times. This young doctor to be, he will be a doctor on 28th, he will be married on 30th, died last night because the road between Umaya and her school is no road. And the only reason for this, all the allocations that has gone to Abia State in the last 70 years of this new administration, nothing has happened to that state because some people took the money. So if we are going to, the jurisprudence of the fight against corruption is that everybody is a victim. Every one of us, both prosecutors and defense lawyers. And we must agree to a point, because my learned brother said something. He said, it is not that conviction should be entered. It's not that somebody should become innocent. It's that, can we allow this case to conclude? Can we allow the case to conclude on its merit? If the case is concluded, everybody goes home. I went to Hong Kong to do a postgraduate program. And corruption in Hong Kong before 1973 was even worse than what's happened to Nigeria now. It was worse. Because that place, if somebody is dying in an air ambulance and he arrives at the hospital, they will not open the gate of the hospital until he passes an envelope to them. If fire is burning and firefighter comes there, they will not pull down their hose until money is given to them. But in 1974, one man stood up, and the legal system in Hong Kong stood by him firmly, the entire legal system. Today, if you give thank you money to a Hong Kong police officer, the money will go to a particular point. They will never take it from you. The money will go somewhere for charity purposes. We can fight this fight, and lawyers are the ones that can fight it best. Let's team together. And these people, I've seen files now, up to today. I saw a file yesterday. If you see the money that move from individuals that all of us know their names, that are walking on the streets of this Nigeria freely, and we are trying to prosecute them, and we are having difficulties. If you see the money they move to accounts, the money will even be there, it will not be used. EFCC say, come, they say, okay, we are bringing the money now, we are bringing it now. We have to fight this fight. It's not defense versus prosecutors. All of us must fight it. Thank you, sir.
I think there's a point already made here in favor of the seeming partial treatments given by government to prosecution cases. The point is, in our system now, corruption appears to be the breeding ground of other crimes. And its effects are pervasive. Corruption case committed here, you have money for roads, it will release and somebody pockets it. It may affect somebody hundreds of kilometers away from here. The road is not done, and we have this scenario he narrated. So we should all work together now. This may be a tip of iceberg. And from its body language, I think this will be done from quarter to quarter. So that as you study these papers, when we come back, perhaps under a different theme, we throw more light on these things. Now, we'll go to this side.
The FCC man wants to leave, but the press wants some group photographs. We'll take one.
My Lord, I think the only reason I was invited to this seminar, invitation for which I got at the Court of Appeal yesterday, is because I am defending one senior advocate of Nigeria alleged to have been involved in corruption. But I will explain why the issue of defense counsel is important, because my personal experience was that when that case started, 35 SAN or so were prepared to defend him. I'm the only single SAN defending him today. Because right there in open court, defense counsel were being blackmailed and being informed that either that they had clients who had cases with them, or that they themselves were being investigated by EFCC. So it is actually true that defense counsel presently are an endangered species. It might not be orchestrated, it might not be planned, but that impression is there. Now, for us to understand the challenge we are facing, this is not about defense or prosecuting counsel. And let me concede something for the government side. What the fight of the government is doing is helping everybody, and an instance will demonstrate that. I don't know how many of you on a daily basis receive account number from people you don't even know, asking you to transfer money because they are in one distress or another. You have given us, for instance, a good answer. And somebody sent an account and said, look, have you heard about people saying that the money they receive into the account, do you know it was from government purse? Do you know that if the money I'm sending to your account is going to be queried later by EFCC? So, in a way, the fight is for everybody. But the manner of the fight may actually lose the moral of the fight based on the tortoise and his in-law's case. You all remember the tortoise and in-law. When the tortoise was tied down on the way out over an allegation, everybody was condemning the tortoise. But when he was kept shackled until evening when they were returning, and they still found, they now say, even you, the in-laws, this is excessive punishment. So it's better we adopt smart prosecution, which means, for instance, and I know this is not the way Americans fought it. When Americans found that they could not fight corruption the way you are doing now, they went for tax issues. And that's why Professor was right in one thing. The burden of proof in tax matters is shifted on the tax defaulter, right from the primary body. Because once you are assessed, best of judgment, and you cannot explain, when you are in court, you are first of all justify how you came about the money. Why are we running away from that? Why are we still looking for money that you can just get an interim order to at least forfeit the interim? And I explain why. This is the only country where we have removed failure to pay tax as a qualification or non-qualification grant to hold public office. This is the only country where a bankrupt can hold office of trust, whether public or private trust. These are the things I believe the government should also look at. Having said that, my Lord, may I refer to Rule 33 of our professional conduct to explain why some of the issues raised by the learned and J.B. Dado are very critical, not only for defense, but all of us. Rule 33 of the Rule of Professional Conduct reads, a lawyer or a law firm engaged in or associated with the prosecution or defense, my Lord, I'm emphasizing prosecution or defense, of a criminal matter or associated with a civil action shall not, while the litigation is anticipated or pending in the matter, make or participate in making any extrajudicial statement that is calculated to prejudice or interfere with or reasonably capable of prejudicing or interfering with the fair trial of the matter or the judgment or sentence thereon. Arguments that have been traded here today shows that some of our colleagues, whether for prosecution or defense, have inadvertently been flouting this rule. Otherwise, we will realize that it is the entire profession that is at risk when we denigrate our profession and begin to engage in media trial, either by defense counsel or prosecution counsel. And it should not be debated anymore. People that are found wanting of this should be made to undergo disciplinary trial by our profession so that the issue of self-regulation can be brought to bear. If we have that, that solves a lot of problems. But more importantly, sir, is that in matters of this prosecutorial power, I beg a little bit, sir, to differ from the paper by Mr. J.B. Dado SAN on the issue of allowing prosecuting counsel to participate in investigation. My experience is that it's better they allowed independence of judgment to make up whether to prosecute or not. When they are already involved in investigation, tendencies that is their view are already colored, and they are unable to form independent opinion whether a matter should go to trial or not. In Lagos State, what they have done, sir, is that they have provided for non-lawyer prosecutors to submit their papers to the Minister of Justice for legal opinion before they file charges. In EFCC, the Act designed prosecution unit and investigation unit. But what we find is that the two units are working together. And therefore, even when an independent counsel like Rotimi Jacobs might not, based on his own assessment, conclude that prosecution was due, not that it's not likely, but that as at that stage was due, they tend to file those charges, and when they run into murky water, they invite private prosecutors to come and take over the prosecution. And these are part of this issue you must look at to see why cases are being delayed. It's very, very important. I've been involved in a case where somebody was alleged to have bribed some people, and none of those people were interviewed, and his statement is the only reason they are filing a charge in court. No, I'm just saying, I'm not saying whether right, but I'm saying these are reasons I believe a lawyer would not, an independent lawyer would not have allowed you to go and file charges against a person for allegedly giving bribe to somebody without interviewing that other person. None. So, and when you have those kind of cases clogging the docket of the court, you cannot blame either a defense counsel for challenging those kind of charges in court. How do I advise my client, my lord, sir, to plead guilty to that kind of allegation when the other side has not even been interviewed at all? I don't know what his response is. And I've denied the allegation. So only my denial is what has formed the basis of filing charges in court. So what we are saying is that the prosecution should now start with what I call smart, proactive, rather than reactive prosecution. Because all that is going on here, we are looking at corruption that happened before 2015. We are not looking at corruption going on now. And that is why it appears that the government is losing the moral of its very well-intentioned initiative to stop out corruption. Thank you, my lord, sir.
A very vital point has been raised here about the press and lawyers and the press. It's very uncommon. You don't see, if you don't see it, you read in the newspapers. As soon as the court rises, you see the press conference. One lawyer, the prosecutor is here, the defense is here. Everyone said, I'm going to win this case. We'll do this, we'll do that. At the end of the day, if the case is not won, who is to blame? The judge and the lawyers too. So I think we should refrain from that. At the end of the day, when you win, call everyone to listen to you. If you lose, go and lament somewhere.
Well, yes, Mr. Chairman and other participants, I'm sorry for coming late. It's not in my character. I was in court and I was delayed. Before I talk on the corruption scene, let me make a comment on one or two points made since I came in here. Now, I heard Owonikuko say that he's objecting to prosecution being involved in investigation. Well, maybe if we try to borrow from the practice in other jurisdictions, you might be able to see the benefit of their involvement at the very initial stage. You see, when I was privileged to serve this country, I interacted a lot with the outside world. And I was in the US, I spoke to the attorney generals. I know they had 4 attorney generals at that time. And they said to me, at the very beginning, when the police are investigating, the prosecution is involved. So if they don't have enough evidence to go to trial, the prosecution, who will handle the prosecution, would know. And they would, of course, advise against it, and nothing will happen. But where he has no opportunity, instead of being involved, and they just send to him a heavy file, particularly in this country, where they expect you to make some magic. A week after they've sent you the heavy files, obviously he cannot digest the file thoroughly. Whereas if he had been involved from the very beginning, he would know the case sent to him to prosecute. That's my comment on that. Now, the time for prosecution is also very important. You see, in this country, we rush to court. And in every criminal case, you find that after trial has started, the prosecution is serving additional proof of evidence, number 1. Additional proof of evidence, number 2. Number 3. That happens. That means they had not fully investigated their case. So you don't have to go to court. There must be, you see, an ability by the prosecutor, particularly the external ones, you see, to prevail on the commission, given this case, that look, I can't go to court next week. I have to study this case and know whether I need 4 counts or 10 counts, and not 50 counts or 104 counts. The Supreme Court has lamented in some, look at the case of George and the FRN and Ola Madiribi and others. They said that initially the count was over 106. Then they brought it down again to about 100. A third time, they brought it down to about maybe 50-something. Yes. Whereas it could have been done with just 1 or 2 counts. So these are the kind of things that delay trial of cases. You don't have to call a host of witnesses. You yourself must be able to assess your case and evaluate it and say, okay, can I be able, to gain a conviction on these counts? If you know the type of evidence you need and the quality of evidence you have at your disposal is not enough, can I help you? Then you say, look, I have to drop that count. So these are the things we also have to take into consideration. So that one. Now on the issue of corruption cases, you see, one has listened and read in the papers, we cannot deny it, that there has been an attack, on defense counsel. And when these meetings or seminars or programs are held, the defense counsel, you probably are commenting on, are not even invited. So they have the opportunity of expressing, their own side of the story. Now, what we should have in mind, let me refer to the post-Second World War event when they set up the Nuremberg trials. There are comments all over the place that, what do we do with these criminals now? The US, the Soviet Union, the UK, they were divided in their approach. Some said, look, those you can identify on your own list, let's get them out and execute them. Some said, no, let us not subject them to that kind of treatment. Let's give them some kind of hearing under what they call organized justice. And the US had its own list, UK had its own list, the Soviet Union had its own list. And they wanted them, they said, look, you don't have to waste time, on hearing anybody. We know they committed these offenses. So what are you waiting for? Send them to be executed. All these things happened. Now, at that time, there was the Associate Justice of the Supreme Court, Robert Jackson. He was then the president of the American Society of International Law. He made a comment. He said, I have no purpose to enter into any controversy as to what shall be done with war criminals, either high or humble. If it is considered good policy for the future peace of the world, if it is believed that the example will outweigh the tendency to create among their own countrymen a mist of martyrdom, then let them be executed. But in that case, let the decision to execute them be made as a military or political decision. We must not use the forms of judicial proceedings to carry out or rationalize previously unsettled political or military policy. Farcical judicial trials conducted by us will destroy confidence in the judicial process as quickly as those conducted by any other people, of course. If good faith trials are sought, that is another matter. All experience teaches that there are certain things you cannot do under the guise of judicial trial. Courts try cases, but cases also try courts. You must put no man on trial. And let's listen to that carefully. You must put no man on trial before anything that is called a court. If you are not prepared to establish his personal guilt, but further, you must put no man on trial if you are not willing to hear everything relevant that he has to say in his defense and to make it possible for him to obtain evidence from others. Any United Nations court that would try, say, Hitler or Goebbels would face the same choice. The ultimate principle is that you must put no man on trial under the forms of judicial proceedings if you are not willing to see him freed, if not proven guilty. If you are determined to execute a man, in any case, there's no occasion for a trial. when you take a person accused of corruption to court, you and I know he has a right to a defense. And your constitution says he is presumed innocent until the contrary is proved. Unless now the contrary is proved. Now, you see, these are the back of our mind. We must be prepared. The defense counsel has a duty, and is the one who decides the strategy he wants to use, you see, to address any case he has with him. And the defense counsel doing this is not committing any crime. So we don't have to bash the society against him, and even the accused person and the court. The rules of professional ethics, Rule 7 says, 7A, every person accused of crime has a right to a fair trial, including persons whose conduct, reputation, or alleged violations may be the subject of public unpopularity or clamor. This places a duty of service on the legal profession, and where particular employment is declined, the refusal of the brief to undertake a defense may not be justified merely on account of the guilt of the accused or repugnance towards him or the offense as charged. Again, Rule 9 says, it is the right of the lawyer to undertake the defense of a person accused of crime, regardless of his personal opinion as to the guilt of the accused. Otherwise, innocent persons, victims, only to suspicious circumstances might be denied proper defense. The lawyer is bound by all fair and honorable means to present every defense that the law of the land permits, to the end that no person may be deprived of life or liberty, but by due process of law. And of course, on the prosecution also, we have a provision. That's 9D. The primary duty of a lawyer engaged in public prosecution is not to convict, but to see that justice is done. The suppression of facts or the secreting of witnesses capable of establishing the innocence of the accused is unethical and subversive of professional conduct. You see, these things are there to guide us. So it's not as if defense counsel go there, you see, to frustrate trial. No. They have a duty to exploit all available means to defend, you see, their client. Don't expect that the prosecution is expecting within a month, I want this case out of the court. I want a judgment in this case. But that does not bind me as a defense counsel, because I know what strategies to apply in every given case that I'm defending. So these are things we have to bear in mind. Lawyers who defend people accused of corruption are not aiding corruption. But these are people I have a duty to render service to, and I cannot decline to render this service to them. And the Supreme Court, if that's again the case of Georgia and their father and others, you see, declared a situation where people are tried, you see, in newspapers, and they are condemned. The courts were warned in the decisions that judges must base their decisions on the evidence before them and not public view of what they think should happen. These are things, you see, we all have to appreciate and then work within. Nobody is out there to frustrate the prosecution of any case. But while we are trying to put in our best, let us also be understood that we are part of this country, and we all are committed, you see, to fight corruption, because we know the danger it poses society, and if we all keep quiet, we all, of course, will suffer, from the effects of corruption. So it's only an insane person who will say, oh, let people be corrupt. All over the world, the fight against corruption is raging every day. Nigeria is a party to the anti-corruption treaty, which was had in December 2003, when I was in office there. So we have a duty under this multilateral treaty, you see, to fight corruption. We cannot shy away from it. But we need, you see, some kind of systemic review, you see, to ensure that when these cases come, they can get prosecuted and they're disposed of within time. Very much obliged.
Thank you very much.
Yes, I'm coming. You see, the defense lawyer is in the same boat as the Judas Iscariot. If he doesn't play his part, the law will not be fulfilled. So I suggest that we agree that he should be given every facility to do his job. But remember, whether you are defense or prosecuting, integrity.
My Lord, my conclusion is simple. This conversation would have to realize that most of those who are standing trial today for what we consider high-profile corruption were at one time leaders in this country. So even those who are leaders today, I mean, they are not above being brought to trial if reasons arise. So the point I'm making is that let us get the procedure right so that it will serve as a precedent which will serve everybody that has occasion to be exposed to trial for corruption. There's no point saying it's us and them. Corruption as it is condemnable in all the sense of the word, in all ramifications. But let us get our procedures right. Let us fight corruption with precedents that we could use in every situation. Because those we are talking about today, yesterday they made the laws for us. They are those that when they sneeze, we catch cold. Yesterday. Today they are being vilified and they are being taken around all the courts for corruption cases. Now, what does that suggest? Let us get the procedure right. Let us not have an us and them approach. My friend Jacob today is prosecuting counsel. Tomorrow I may be prosecuting and he might find himself defending. So it is all about the legal profession and the procedure to be adopted in corruption cases across board. The idea of saying, no, the defense counsels are making it impossible for corruption cases to be brought to an end. No, I think we have an elite consensus on the fact that corruption is condemnable. And so the fight against corruption is a fight that everybody seems to promote in Nigeria, but let us get the procedure right. That's the much I would want to say. Yeah, let me just say one or two things. What actually I wanted saying has been rightly captured by the former Attorney General of this country, Mr. Akinlaluji Mesen, together with the contribution of my brother and friend, Awonikoko Esen, also my brother sitting directly right by my right. It's my belief that the entire war can be fought within the ambit of the law. You see, the problem we have is that we seem to be shying away within the purview of various legislations. If we concern ourselves and operate within the purview of the law, we can still get there. The defense counsel will always like to insist on the rule of law being followed. Of course, the prosecuting counsel too, without mentioning anybody, will also be looking for a way to achieve his own prosecution process. I don't want to say that. My contention here is that, for instance, if you charge somebody, like in developed countries, the issue of bail is no longer an issue. Let's go into, long ago they have stopped writing papers on bail, and it's now in this country we still read books how to apply for bail. It's gone. It's gone. My Lord, what I'm saying is that bail should be automatic. Even in countries like Sudan, they have what we call anticipatory bail. As soon as somebody is arraigned, they grant him bail and go into the issues. My Lord, the issue is we have anticipatory bail. For instance, under the Criminal Code of Northern Nigeria, there are classification of bails. Bail is ordinarily grantable, where bail has to come with certain conditions, and you can make an anticipatory bail where the offense is light. For instance, theft. There are so many offenses like that, sir.
where we don't exert energy in application for bail, go and bring her house in Nyanya or in Maitama or Lekki or that's by the way. Where bails are supposed to be ordinarily grantable, you can grant it and go into the offense straight. That is my humble contribution. I'm very grateful, my Lord.
My Lord, the very distinguished, very senior lawyers present, especially the former Attorney General, and then the former President of the Bar, Laden CN, and the note, especially Professor Owasonye, who has been midwifing the anti-corruption fight. This, the committee, this is a very welcome kind of gathering. And the first message we are all taking out of this place is that there is no we against them. There shouldn't be any we against them. Because if Mr. Jacob today prosecutes in court, he doesn't bear a greater burden to sanitize this society than any of us on this side. Because Nigeria does not belong to either you or myself. It belongs to all of us. And we are all trying to ensure that the country runs. Because, for example, Mr. Umo just made a statement now that the powerful men of yesteryears are the ones being prosecuted today. Perhaps those who are defending them, they were their friends in power. Tomorrow, if those who are giving briefs to Mr. Jacob are being prosecuted, I wonder on which side it's going to be. Now, we've made a lot of statements here today, and I endorse all those, especially by my brother, Uwonikoko, by my uncle, Chief Akinolujimi, the lead speaker, and even Professor Owasonye, what he has said. But we seem to be overlooking some other fundamental issues. For example, we are often quick to blame the defense as delaying. But I dare say, without any fear of being contradicted, that what at times the prosecution brings forward is very horrible. In a civilized world, if such a charge is brought by any prosecutor, he will lose his wig and gown. And when an incompetent charge is filed, and you expect a lawyer worth his salt to want to wait until the outcome of the trial of an incompetent charge, then what are we talking about? I was privileged to be involved in a very sensitive matter. It has nothing to do with contemporary matter. It has to do with terrorism, and they call it international terrorism. And I look at the charge, I look at the law. The law clearly says that for a body to be declared as an international terrorist, it must be so designated, gazetted, and all what have you. So when they brought our clients to court then, I asked myself, I said, has this body been so proscribed? Has it been gazetted? And after gazetting, has it been published? Like they did to Boko Haram? And I discovered that it was no. So I told my client that this is rubbish. Now, if I see such a charge, and I go to court, because then when we went to court, they were muscling us, oh, look, come and do plea bargaining. I told my client, say, if you want to do plea bargaining, you can go and do it. But I will never be part of it, because in future, this matter will be reviewed. And the question will be, who is this incompetent bastard lawyer that advised you to do this? Yes, who is this incompetent lawyer? So, my lord, a case like that, where the prosecution and his lordship, we won up to Supreme Court. Then his lordship said, this is a shoddy investigation followed up by an incompetent prosecution.
Why don't we allow all those currently incompetent charges to proceed so that you can be vindicated?
No, Professor, I'm leading to another point, sir. I'm leading to another point. I know, you see,
allow them to proceed so that you can. Professor, I'm not disputing the need to quickly front load and then to make sure the guilt or the innocence is established. But what I'm saying is that when you see some glaring cases, you cannot but be agitated as a counsel, properly trained. Some white people came to me in the office because it was a terrorism case. And I said, look, all the principles you applied there, you taught us in England. I told them. One from the American embassy, the other one from British embassy. I told them, you taught us all this from your schools in England. They kept quiet. They looked at me. I said, will this kind of a charge be filed in England? And they said no. So my suggestion is this. Although Mr. Owonigoko suggested that prosecution should not be part of the investigation, I believe, like some commentators have done recently, one, sir? I agree, but I have an additional suggestion to make, that the investigating agencies like ICPC, like EFCC, should not be involved in prosecution. Let their brief be to gather the information, investigate with whatever, and then pass it to an independent body. Not that you insist, then, until we charge you to court, or we are going to take a remand order, you are going to do this, you are going to do. I believe, sincerely, it is corrupting the system. And as a follow-up to that, we're corrupting the system in the sense that when the same body that investigates is now the one to prosecute, in an attempt to justify the incompetent investigation, it will go ahead with an improper prosecution. Now, Mr. Chairman, sir, then secondly, sir, well, my point is very good. Secondly, sir, it's been said in this country that, well, I'm very happy that Mr. is here, and perhaps we have to take his opinion on this, because I know what he went through as a prisoner of the country. Is it not time for us in this country to have a separation of that office, the Attorney General, who will be like the old DPP under the 1963 Constitution, so that it will be a professional prosecutor, and not one, the Attorney General has gone to England, he has gone to Vancouver, he has gone to negotiate this, he has gone to do that, to the villa. We need somebody who will sit down, he will have a tenure, then you take a matter before him, whether you, they said there are some issues being raised about those of them in power now. Which Attorney General will dare initiate prosecution against, somebody who is instrumental to his being appointed as a minister or what have you? So it is not going to be possible. Therefore, my suggestion, very humbly, is that we should separate the office of the Attorney General and that of the Minister of Justice. There should be a slight amendment to Section 174, so that we will have a thorough prosecutor who will be at the helm of affairs, look anybody in the face. Then it will now depend on his integrity or otherwise. Now, finally, I'm sorry. Because if you don't split the office, if you don't split it, we will continue to run in the danger of dubbing some cases as being political. Even though the Attorney General has filed the correct charges against the right people, once there is this insinuation of politics, then it rubbishes the entire processes. Therefore, it will do well and augur well for us to look at it carefully and then tinker with our main law in this country, so that we can have a sane prosecution. The agencies can be there, they pass it on to them, and then we have the Office of Crime in Britain and all the rest. They will hardly go and do prosecution. Just like when it comes to DSS or what have you, the normal thing, which we knew then, was that they gathered intelligence, they pass it on. But today, what do you have? The DSS, they say they want to prosecute for terrorism, and they are least equipped for that. when you, I mean, what we used to know is they will gather the intelligence. Now give it to the appropriate body to sieve it, dissect it, and then see, oh, can we really make out a case out of this? Then if they can't, they fight. But today, they will do it, do the investigation, do whatever, prepare the judges themselves. They will almost even override the Attorney General, and then go them into filing what they consider to be a proper case, which may turn out to be an improper one. So I think these are some of the areas we have to touch, and not just, and then we should see it as a collective fight, not they, defense lawyers, then we are prosecutors. I mean, this something can change, and I can prosecute tomorrow. The next Attorney General may be Magaji, and I've been praying for it. Or the next Minister of Justice, I'm very grateful.
Now, whatever you say, I believe the two of you should be separated. And I've said it somewhere in two different fora. One day, a law officer, the Attorney General from one of the southeastern states, came to court. Even a first-year law student will tell you that this case is bad. But he had to do it because the governor told him to do it. I said, do your work as Attorney General. When it comes to that one, go and do it. This is their constituency. Subject to what
well, let's wait and hear me. Oh, okay. Ladies and gentlemen, this is a point that has arisen several times. When I was in office, I went to attend a UN conference in Thailand. And as usual, when you go for such conferences, you want to interact with your fellow state office holders. So I now asked to see the Attorney General. Then they called me a man. He sat down with me. We discussed at length. Then I asked him, yeah, the office of the AG and Minister of Justice, are they combined? He said, no, they are separated. Okay, fine. I want to meet the Minister of Justice. He said, there will be a problem. I said, why? He said, I should have seen him first before seeing him. I said, you are Attorney General. He's only a political. He said, that is it. Now, it was impossible, absolutely impossible. That man refused to see me. Why should I go to his subordinate when he was available? Even at that conference, but I had no way of knowing that they separated the two offices. So he refused. Now, when you look at that situation, you may say, oh, well, that was just one occasion. But you do not know how in your own country this will play out. I remember very well that when I was there, you see, we have lawyers from the ministry, in departments, ministries all over the place, representing the office of the Attorney General. Now, many of these legal officers will write opinions for the ministers in these ministries. They will throw the opinion away because it didn't conform with what they wanted. But many a time, they will now refer back to me. Oh, we want to do this so contract. We got this opinion from your legal officer. We do not think it represents the law. I look at it. The same opinion my legal officer sent to them is the same thing I will repeat after looking at the materials I sent to them. They feel obliged, you see, to act in accordance with an opinion under, you see, bearing my signature, because I'm equal in cabinet with them. They cannot say no. Now, if you separate the two offices, how do you rate the Attorney General if you have a Minister of Justice in cabinet? Now, do you create a position for him separately under the Constitution, and he is not a cabinet member? Now, what happened to the DPP that is existing now? Why? Because he's the man who really handles prosecution. You see, he's the man who really handles prosecution. I remember that when Anduaka was there was a proposal by DPP then to him, you see, to create a directorate of public prosecution. Anduaka said no. That would eat into my authority as minister. I don't approve of it. He now came to me asking me to talk to Anduaka. I said, look, I don't have that authority to persuade him to do what he doesn't want to do. So these are the problems. You see, if you are going to separate that office, then you must have some amendments or provisions in the Constitution making him of equal rank with the minister, and also must be a member, you see, of cabinet. No. So if it's not going to be, it's out there. You see, it happened in Kenya. Wait. In Kenya, the Attorney General there, that I met when I was in office, had been there some 12 years earlier, because he was asking me about Chibolagi and all of that. I said, I've been on this seat for over 12 years now. And he still remained, even after I had left. But the letter came now to amend our constitution, I think, to reduce to 5 years or so. So that's the kind of thing they were doing in Kenya until they amended their constitution to reduce the term, you see, to 5 years. So you have to look at this proposal, you see, very carefully. How will it work out? Because it's not as easy as you say they are sitting down, bearing in mind that human beings are the ones, you see, who would operate this arrangement, and the way you and I think will differ. These are many issues. So these are the things, the challenges. I know that in Ghana also they went into a debate on this issue, but again, it's not been clear now whether they will separate or not, and in several other parts of the world. So these are the things we have to look at very carefully. We can debate it and say, yes, when you look at all these evils that may arise, then what is the best way out for us? Thank you very much.
We hear the ICPC man. ICPC.
Permit me to stand on the already established protocol. The chairman of ICPC would have loved to be here, but is unavoidably absent, and he sends his goodwill to this gathering, and he's pleased that such an occasion is taking place. And he asked me to send his goodwill to the organizers of this occasion. Having said that, I just want to make one or 2 points. The fact that there is a need to reform the justice sector in Nigeria cannot be overemphasized. So whatever position we occupy, either as defense counsel or prosecutors or whatever, we cannot deny the fact. Denying it will be running away from reality. And the question I want to draw, the point I want to mention is that we have 5 cases in a place like Maiduguri and all that. At a stage, nobody could go there again. And even some of the lawyers in Maiduguri had to relocate. So when you run away from the reality, at a stage you come to, people are losing confidence in the justice sector and judiciary, and they're taking the law into their hand. That is why you find people, cases that can, ordinary civil matter that can be settled through civil actions. They are looking for police, they are looking for law enforcement agencies to recover, civil, to get justice in ordinary civil matters. So the point I'm making is that we need to reform our justice sector. We need to have, justice in timelessly. Having minor cases that could be settled within a year, dragging on for years, does not do good for our legal system. Having said that, I just want to, agree with the coordinator of this forum that the justice, the FEJ, is commendable. The passage of the FEJ is commendable. But the point, in other systems, the judiciary, the judges could make amendments to the rules, and we don't find that provisions, giving them an opportunity to, I know in England, the rules are amended, by the judges themselves, as frequently as possible, without going through the, we know how long it took to have this ACJ passed. It took almost close to 10 years to have it passed. So there's a need for us to, have such a provision so that we could, amend the rules, from time to time. Having said that, I want to, commend the organizer of this forum and wish that we have such things more often. Thank you very much.
I wish to remind us that our own rules are also made by judges, not by the legislator, our rules of procedure. Now, We have exactly 15 minutes. In 15 minutes time, I'll be summing up. The floor is open to the gallery. Everybody who wants to talk. You have 3 minutes to talk.
My Lord, the danger of speaking almost last is that most of the issues must have been raised. That is the danger. Yes, the fear has been covered. Well, for me, my Lord, the most important thing is the rule of law. The rule of law, as we know, is central to democratic governance and the society. And I believe that the rule of law amounts to due process, following due process. Where the rule of law thrives, definitely corruption is bound to diminish. If due process is followed, corruption will be minimal. Where there's the rule of law, there is that danger by the corrupt of fear of imprisonment or humiliation. And once that fear exists, corruption will be minimal. So we have to look at enhancing the rule of law, due process. It is not an argument of whether you are a prosecutor or defense counsel. All of us have to support the enhancement of the rule of law. Once that is done, everything will be taken care of. That is my humble contribution.
O.A. Adebolu is my name. I am in the invitation. The chairman of this occasion, the convener of this meeting, all other protocols duly observed. In the invitation that was extended to us, we were made to understand that the Commandant General of Civil Defense will give a goodwill message, and I'm representing him. I have a short message that I will just present. Kudos must be given to the organizers of this event for choosing the topic, the remit of criminal courts, and the role of complaints without substantive evidence. Lack of adequate training for investigators and prosecutors is one of the problems. Emerging issues on corruption fight. The enactment of the Administration of Criminal Justice Act 2015 into law to regulate criminal procedure is a welcome development, as it has entrenched speedy dispensation of justice. Although there are some provisions of the Act that have been acted by legal practitioners, especially as it relates to preliminary objections, it is my view that the provision of the Act 2015 is the position of the law as it stands. Regular legal practitioners with divergent views could approach the cause for interpretation. Section 17, subsection 2, Act 2015 has gone further to state that statements of the suspect may be taken in the presence of a legal practitioner of his choice, any choosing member of his family or representative of the Legal Aid Council, or a justice of peace. This further promotes rule of law. Again, a suspect should have access to a legal practitioner of his choice and should be given adequate facilities for his defense. There has been clamor for the creation of separate court for corruption cases. However, cases relating to terrorism, kidnapping, or theft should not be left unattended to, as they deserve special attention too. Once again, I thank the organizers of this seminar for conceiving this idea at this point in time. O.A. Adebolu, Assistant Legal.
But there's only one meaning. Nobody's above the law. Even the president is not above the law. Well, for a short time, the president, the vice president, the governor, and deputy governor may be said to be above the law for 4 years only. As soon as they leave, you can start proceedings. But other than that, everybody is equal before the law. We should not commit the entire state arsenal because a big man is involved.
In the name of the Father, and the Son, and the Holy Spirit. Everlasting Father, Father, we thank you for this great day. Father, we thank you for making it possible for this function to go on. Father, we have now come to the end. May you send your Holy Spirit to come and be with us, guide us as we go back to our various destinations. We ask all this in Christ's name. Amen.
Very robust discussion we have on the remit of criminal courts and role of legal practitioners in corruption cases under the existing law. Organized by the Rule of Law Foundation, a discussion that should benefit all Nigerians.
There will be light at all times. This message is brought to you by the Nigerian Television Authority, NTA.
Information is power. Everyone wants power. So feel powerful with the NTA News mobile app, the one-stop information center. Real news at your fingertip. Be the first to report by uploading first-hand information on the You Report link, and be the first to know by simply clicking on any of the links on the sidebar for headlines, domestic and foreign news, economy, security, politics, sports, and more. Stream live on your smartphone and tablets and stay connected. It's pretty easy. Simply download NTA News app from your Google Play Store and you're good to go. NTA News mobile app, your access to real-time information.
NTA Language.
Jama'a masu kallon labaran NTA Hausa barkanmu da warhaka. Ni ne.
Ekukale lo da yin yawa su kude da.
Igbo murum kachano.
Broadcasted in the language you understand better. Our programs. Transmitting on the Star Times platform 24 hours.
Àwọn onímọ̀ nípa ètò ẹ̀kọ́ lórílẹ̀‐èdè Nàìjíríà.
Hukumar tara kudaden haraji ta ƙasa.
Alanye na ọchịchị mba United Arab Emirates UAE.
The only channel that speaks your language.
Anyị ga-eweta akụkọ gbasara ọrịa ahụ nke wakporo obodo anyị.
Kálejì, mo kọ́kùnrin, mo kóbìnrin, mo kí ọmọdé, mo sì kí àgbàlagbà.
Mu ci gaba da yi ma rundunar sojin ƙasar nan addu'a.
Ẹ kú lẹ́yìn tèmi, ẹ káàbọ̀ sórí ètò wa ètò yín ètò obìnrin tó dángájá.
Waye fi cancanta a ɗauka a matsayin ɗan aikin cikin gida.
Jama'a
masu kallon tashar NTA Hausa barkamu da warhaka.
Kí ni ayẹyẹ ọdún iléyá tá máa ń ṣe lọ́dọọdún yìí rọ̀ mọ́?
NTA, you can't beat the rich.
Nigeria is often described as a country of unity in diversity. This description probably stems from the fact the country is made up of over 400 linguistic groups. The onus therefore lies on us to evolve strategies of harmonizing the rich cultural heritage that abound in Nigeria to avoid erosion of the cultures and traditions of about 250 ethnic nationalities in Nigeria.
NTA, you can't beat the rich.
Plateau State is one of the states in Nigeria that is blessed with many culture and traditions, resulting to a good number of languages spoken amongst the people. One of such people with an interesting culture and tradition is the Amaru ethnic group. The Amaru people are found in Jingur, Basel local government area of Plateau State. According to oral history, they are believed to have migrated from the northeastern part of Nigeria.
The history we have is that the Amaru came from Niger and settled at Borno. From Borno, they came to Pengal.
Amapurunzu areke amapartuwa nuzu kipini dusu mimbochu dinganu daga bochi.
Amurunzu people migrated from Bauchi to Kondonkaya, from Kondonkaya to Pingel, to where we are today called Jingir.
Kunde, the ancestor of the Amaru people, is said to have settled on this hill called the Runzu Hill.
History tells us that when they came from Kondonkaya, they settled at the present hill of the Runzu people. The hill is in the east of, southeast of Jingri town. That's the hill where I think maybe you have gone to that place and see. That's where we call the Runzu Hills.
Getting to the top of the hill, where it is believed the ancestors of the Runzu people lived, could be described as a challenge.
Unanda ke nuzu daga Maiduguri har. Ne nuzu daga Niger idau Maiduguri. Daga Maiduguri ida.
This is the Runzu Hill, where the ancestors of the Amurunzu people settled. He migrated from Niger to Maiduguri, from Maiduguri to Bauchi, from Bauchi to Pingel, and his name is Kundi.
A ganin nuzu kusar kadas nenge. Ame ku ganan na fukuran baturi arba. Lumusare ase kellangare kefu koremu. Ya kefu koremu in mozun ne chize.
At the top of the Runzu Hill, our people use stones to make their farming tools. This is where women, children, and the old used to settle and dance around.
Minera vati kipina kupara kwane asa tusono minene awani datiza ediso nati nadi nimmo memba sede mone mi duñu ci daga ki tener nani mi tolso ku bili wadak asa mi so tum asa wane da fi yesa fi nuzu fi danno ko awane se wor fi.
The myth surrounding this spring water hole is that a snake used to serve as the guardian of this water hole. People come to appease this snake before fetching water from the water hole.
Iburun torotu bukimu minere matizo isuli kanjumu minere matizo iso minere matizo idisosomo fatu kupara kongana minere inatiza.
In ancient times, the Amurunzu people were warriors and had enemies all around them. As such, they had charms to protect bush fields and crops.
This is the charm we use in protecting our farmland and to settle disputes. Once the charm stands up, we have blessings, and if it doesn't, then there's a problem.
At the dawn of civilization, Amurunzu people started coming down from the hill to live on plain ground called Kalambai, from the word Columbite.
Ya tolu daga kuparare ida saki kangana isaki kana maloro bani daki kangana kafin.
Legend has it that this is where the Amurunzu people settled when they came down from the hill and made contact with the white people during mining. It is called Kalambai from the word Columbite.
The Amurunzu people are predominantly farmers. They cultivate food produce such as maize, beans, millet, soya beans, sorghum, and vegetables, among others.
This one is a human being. We have just shown the people, want to show the people that our people are farmers. You can see this is a hole. This is just to tell other people that people are farming here. And this is the God that is protecting these farmers. And that is why we show this man standing. The man is standing so that anybody that is passing will see a man going to the farm with his own hoe. And as you can see, this is a woman. There is no way in Amolan we regard women with great importance. In fact, if you are a thief in our place, you don't get married. Nobody gives you a wife. And we have one custom. It is believed that when you have more than one wife, you are a great man. But if you have one wife, completely you are considered not anybody. A lazy man and somebody that is not considered in the society. So when we are going to the farm, we organize women, beautiful ones, young ones, to come and dance for us. And that is why in our shrine, we will put this one as to show that we are farmers. Then we put this one as a woman who is supporting us to farm, because without the woman, you won't even farm. When you saw when we are doing this in Zara, you saw women following boys, trying to tell them to what? To give them encouragement. Because without the woman, their woman will not even farm.
They were farming and hunting. Well, the products were guinea corn, tamba, and rizga. These were the type of crops that they were farming. They are producing it in large quantity. To be able to eat and to exchange if it so needs. You will exchange with somebody who has something. If you don't have douro, then I have tamba. I will give you douro, you give me the tamba.
They also rear animals like goats, sheep, and chickens. The traditional architecture of Amarunzu people are simple round huts made of mud and clay and thatched with grasses. They center their religious beliefs on the worship of Insil or Dodo, who serves as their god.
Somebody wants to send any spiritual thing to come and affect those people farming in that particular place. This horn and this arrow will protect it. It will only end here. As you can see, look at this little thing that is holding this entire horn, entire arrows. You can see it's a very small thing. It shows that anything coming into us as we are farming, this thing is going to protect us. It's just like our God in the traditional time.
The Amarunzu people have tribal marks. These are called eoliths.
Parents used to have it. You see them fashioning the whole of their face like that with it. And I brought some old men that were typical example of that. Well, the young men today, they have their own, they will have 3 here, 3 there, and some on their chins and their nose. That's it. So their own ones not spread like those of the old men. Okay. Women too, they have their own different type. And that of the women, they have it in the face. Some of them do it in the hand.
A major festival of the Amurunzu is called Iani.
Inyan was a sort of community farming. Those rich people in the Amo land, he will buy a cow, and then he will invite the youth to come and farm for him.
This farming festival At the Iani festival, the lives of all the participants are a major concern.
Uta ninkuboro kubin mburne na de ya de ne kawai amu wanye de ya munu.
Those with bow and arrow are responsible for the protection of the participants of the Iani festival.
Apart from promoting and encouraging farming, the festival accords an opportunity to select a hero called Barde, who will rule for the next 5 years. Once the Barde is selected, he will then be presented to the elders for their blessings.